All persons having business for the Honorable Associate Judges now residing over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Good morning, everyone, and welcome to virtually to the District of Columbia Court of Appeals. We have one case on this morning's calendar. That case is Riley versus District of Columbia Department of Employment Services, case number 19AA974. We'll hear first for counsel for petitioner, Mr. Snyder.
Thank you. Good morning, Your Honors. May it please the court, David Snyder on behalf of Moses Riley. May I reserve 3 minutes for rebuttal, please?
Sure.
Thank you, Your Honor. We're here today because the workers' compensation system, which is designed as a safety net for anybody who is injured at work in the District of Columbia, is designed in such a way as to ensure fairness to the adjudication of the rights of the parties and to prevent unnecessary burden on both the executive and the judicial systems. This case presents an important legal question as to whether the procedures prescribed by the DC Workers' Compensation Act, as well as its enabling regulations, are mere suggestions or whether they're required procedures that the parties must follow in order to ensure those rights are fairly adjudicated and that there is no unnecessary burden upon the courts or the administrative agency. So, in the context of this case, in order for an administrative tribunal to exercise jurisdiction over a matter, there, of course, must first be a case or a controversy. In the workers' compensation system, we typically see that in one of two ways, over either medical care and treatment or compensation for disability. So when a person is injured at work, the system is designed so that voluntary payments are encouraged by the insurance companies for the various employers within the district, and that they also voluntarily authorize and pay for treatment in order to get the injured worker better and get them back to work. It's only when a controversy develops that the system comes into play, whether it be through the informal conference process that's been prescribed by the regulations or through the formal hearing process that is a part of the act. So I think this case really boils down to whether this court believes that the word shall has its normal meaning that the court has given to it over time to be a mandatory prescription, or whether this court wants to do away with years of jurisprudence as to what the word shall really means.
Just to orient us a little bit. Just to orient us a little bit, you're pointing to the word shall in the statutory language that the mayor shall issue a recommendation after the informal hearing process. Is that right?
That's one of the places, Your Honor. Yes. So I think Section 1530 of the Act is really the only place where the informal conference is even kind of hinted at. The informal proceedings before the Office of Workers' Compensation really are creatures of the enabling regulations. So in the context
what's your response to, we've already rejected that argument in Kelly?
So this case is really a little more broad than Kelly. So Kelly did discuss that, and quite frankly, I think Kelly was wrongly decided. There's a lengthy dissent in Kelly by Judge Easterly, where she goes into pretty deep detail as far as what the act and the regulations actually state. And this court needs to consider all of that in total. One of the things that was absent from the Kelly decision was
Mr. Snyder, I'm sorry to interrupt, but to the extent you think that Kelly's incorrect, there's really nothing that we as a division will be able to do to help you with that line of argument. And so, that's a matter you could take up with the en banc court, of course. But do you have an argument about taking as an assumption that Kelly is correct, why your claim still can succeed on the merits?
Sure. So Kelly did not consider all of the all of the law. It did not consider the case or controversy requirement. And Kelly, it was either assumed or taken as a given by the parties that the employer and insurer had standing in that case to file for a formal hearing. And
Can
there's
I just make sure I tell me where, I mean, I think your opponent's argument is something like this. There's clearly a controversy. And in fact, your client submitted a claim in front of an agency, and there is an administrative mechanism to resolve that claim. A component of that is to, query whether there are procedural missteps at all, but still, just in terms of standing, your opponent is saying, I am disputing a claim that someone has brought against me, and I have standing to argue that I'm entitled to a hearing, a formal hearing, and I also want to argue that once there is a formal hearing request, the informal procedures are not available. Why is any of that? Why don't those considerations suffice to confer standing on your opponent to, again, try to persuade the ALJ, the CRB, this court, if need be, that the claim should be resolved in that way?
Sure. So I think there's really two parts to that answer, Your Honor. The first is that I don't know that we can assume that there is a controversy based on how the employer acted in this situation. And what I mean by that is it really goes to the requirements of the regulations. So Title VII, DCMR, subsection 209.1 requires that at any point in time that the employer or insurer controverts the right to compensation, that they must follow certain procedures in terms of filing a notice of controversy. In this case, that was not done at the informal conference level or at the Office of Workers' Compensation where it should be filed. After a formal hearing was requested by the employer and insurer, they still didn't file it. To this day, I don't believe that there's been a notice of controversy filed as to Mr. Riley's rights to permanent partial
Can I ask you about that
disability
point?
benefits.
Because I don't recall in your brief or in front of the CRB that point was made, that really the employer has kind of lost any ability to contest this because there was no filing of a notice of controversy. Is that a point that was made and I missed it, or is that a thought that is occurring to you more recently?
Sure. So it really is kind of weaved into the standing and subsection C. I don't remember if that's 1C or 2C of my brief, or my argument, excuse me. Subsection C of the argument, we discuss the employer's failure to exhaust administrative remedies. So it really, I don't think I made that particular point in the brief as far as
in fact, I thought the specific point you were making about that was that they failed to go through the informal conference process. I just hadn't been aware that a part of your line of thinking was that where things went off the rails here was that there should have been filed a notice of controversy. Can I ask for a second? I know this is kind of jumping into the middle, but we're in the merits now, and there is a serious set of antecedent questions about whether we should be discussing the merits. The order of the ALJ is not sort of classically final. It doesn't end this matter on the merits. And the order of the CRB also is not classically final and doesn't end this matter on the merits. And so there's a dispute about whether the CRB was right to refuse to take review of the matter and whether we should or shouldn't take review of the matter. And can I ask you a factual question about that too? I saw from the CRB's order that the ALJ had sort of stayed further proceedings on the merits pending a ruling from the CRB. Am I right to infer that although there is now a ruling of the CRB, there still is some kind of a stay where no formal proceedings are going on? Is that a correct assumption?
In this particular case, yes, that is correct. What happened was the administrative law judge agreed to issue the order. So we had filed a motion to dismiss on the basis that there was no jurisdiction for the administrative law judge to hold the formal hearing. That was denied, but in the process of, I think there was a conference call that happened. The administrative law judge agreed that in the order he would stay any proceedings in this matter subject to the appeal playing out before the CRB or ultimately this court. So that's correct that Mr. Riley has not had either an informal conference or a formal hearing regarding permanent partial disability benefits to which he might be entitled. So just to kind of go through the analysis, and it's detailed in our brief, so I don't want to spend too much time on it, but for interlocutory review to be appropriate, there's three requirements that must be met. First, it must conclusively resolve a disputed question of law. So I understand the counter to that is that Kelly resolved this disputed question of law, but again, I think there's certain concerns regarding standing as well as the procedures that were not addressed in Kelly that we're asking this court to address here in this case. Second, there has to be an important issue separate from the merits of the case itself, which very clearly the process and procedure is separate from whether Mr. Riley is ultimately actually entitled to anything. And then third, it has to be effectively unreviewable on appeal from a final judgment. So we cited in one of our...
Can we pause on the second prong for a second? Because it's certainly true. These processes carry some import, but at the end of the day, if the employer wants to, they can always invoke the formal hearing procedure and then go up through the CRB. So I think part of their point is you're going to end up in the same place anyway. And whether or not you can skip that sort of initial step of the informal process is really not so critical at the end of the day. Something that the regulations say anybody can voluntarily opt out of. What's your response to that?
So I don't think that I don't agree that that's what the regulations allow for, Your Honor. The regulations say that participation in an informal conference is voluntary. That doesn't mean that you can skip it. That just means you don't have to be there. Because
those two sound like the same thing to me, but keep going.
No, so it means that an informal conference can be held absent one of the parties being
Oh,
there.
sure.
Because...
I mean, that's a perfectly good point. Footnote 6 in Kelly, which you stressed a bit in opposition to the motion to dismiss, and then seem to have sort of neglected in your briefing, seems to suggest those two things are in serious tension. Because not only do the regulations say you can voluntarily skip the informal hearing, but that the informal hearing will cease when somebody opts out of it. So that seems to be incompatible with your view that there needs to be, that the regulations, and Kelly says maybe those regulations are in conflict with the statute. The court said we don't confront that here because it's not being raised, but I take it you're raising it here.
Sure, and what I would point to, Your Honor, is if we're going to cite certain regulations, we have to look at all of them. So in that same subsection of the regulations, which is 219 of Title VII, 219.8 says specifically, each controverted claim or medical benefits shall be investigated by the office. The office shall attempt to resolve disputes with respect to a claim in a manner designed to protect the rights of the interested parties at the earliest practicable date. And I don't know any more clear statement that the Office of Workers' Compensation must adjudicate this first than that.
Counsel, let me interrupt just to perhaps oversimplify this with a capital O, if possible here. We have an appeal here, interlocutory appeal to this court of the denial of an interlocutory appeal at the CRB level, right?
Correct.
Okay. And why, therefore, unless there's an exception, doesn't the failure of the party to exhaust administrative remedies before the CRB, get their complete ruling on everything, why doesn't that preclude our looking at it? End of discussion.
So I think that really goes to the third prong of the interlocutory review requirements, Your Honor, which is that it has to be effectively unreviewable on appeal. So in this case, as in Kelly, one of the major potential issues is that Mr. Riley would potentially be able to have the employer responsible for paying attorney's fees at the end of the day if he's successful before the administrative law judge, assuming that there was first an informal conference. So it's essentially a, you can't unring the bell argument, right?
Well, you can, maybe this is too simple also, but ultimately, isn't there a way of challenging Kelly, even all the way to the unbanked court, that could unravel all this way back to where you get the informal conference?
Absolutely, and that's what we think should happen in this case, because in order
that permits a review without having to go to the merits. It just simply sends it back and say, start where you should have started, at the CRB, and get finished.
Sure, but once there's been a formal hearing held and it's adjudicated a matter, you can't go back and then have an informal conference on the same issue and then work your way back up, because unless it's a modification procedure under 1535 or something of that nature, that's just not how the process works. So
Well, I'm not sure that's correct. I mean, it might be practically correct, but theoretically, let's imagine that we denied interlocutory review, and then the matter went on to a formal hearing, and assume your client prevailed, but was still concerned about the loss of fees that might have been available if proper procedures had been followed, and your client seeks review and goes to the CRB, and eventually, let's say it comes to this court, and this court says, you know what, actually, Mr. Kelly is right. It was an error to go to a formal hearing and all of that, and to get an award here without going through informal processes first, at least to the extent of getting a recommendation from the mayor. So we vacate the order that was entered. So everybody is back to ground zero, and you send it back, and then there would be an informal then I assume there'd be an informal recommendation, and then the employer would have to figure out whether to make voluntary payments during the period between the informal recommendation and whatever process there was to gear up, have a new hearing, and get a new final order. So it doesn't seem like it's impossible. I can see the practicality. I see some practicality issues, but why is it theoretically unavailable for us, if we were to be persuaded at the end of the road of this after a final order, that there never should have been a final order, there should have been an earlier process? Why couldn't we send it all the way back to ground zero?
That's an interesting point. I think that the major issue with that would be that the CRB would be vacating the conclusions of law. There are still factual findings engaged in by the administrative law judge that, like it or not.
No, I'm hypothesizing that we issue an order saying we vacate the ALJ's order because there never should have been a final hearing or any order arising therefrom. And so the parties are, the ALJ is, or really DOES is directed to, make an informal recommendation first. And we're vacating everything that went before.
I've never seen that that play out. I do think that still, even if it's vacated, there's still a problem with there being findings of fact by the administrative law judge that then become binding on a claims examiner at the Office of Workers' Compensation, as well as a subsequent administrative law judge, regardless of whether they reach different conclusions of law as to either entitlement to permanent partial disability benefits or entitlement to a certain amount of them. I think there's still practical issues as far as that goes, just based on the cases regarding permanent partial disability, whether it be Jones or Dent or any of the cases that kind of discuss the various factors to go into that analysis. I suppose it could happen, but I think it, again, one of the real problems with that though, is you've now imposed an unnecessary burden on both the agency as well as this court for everybody not following the proper procedures, when it could have been much cleaner and had everybody followed the procedures, had OWC exercised jurisdiction, and then the administrative law judge.
The problem with that line of thought is, you could say that about all interlocutory appeals. You could say, look, if the trial court is going off on the rails early on, or the agency is, let's take an interlocutory appeal. Let's get the views of the appellate court and make sure that we're not going to waste our time. But the general assumption of the law is that by and large, it's more efficient to wait and do everything at the end and fix mistakes rather than, bouncing up and down. But I know you're over time, and so I do want to give you your 3 minutes rebuttal, but we'll hear now from DOES and the intervener. And Ms. Anderson and Mr. Dat, have you agreed as to how you're going to proceed in terms of order and division of time?
Yes, sir.
We have your honor. We will divide in our time, and I'll be proceeding first with the first 10 minutes, and Mr. Dat will take the remaining 5.
Thank you, Ms. Anderson. You may proceed.
Certainly. May it please the court, Stacey Anderson on behalf of the Department of Employment Services. Initially, I do want to just thank the court for granting my motion to continue the argument in this case. I very much appreciate the court's willingness to accommodate my scheduling conflict. So thank you. With respect to DOES's position in this appeal, we do believe the court should dismiss it because it is an interlocutory appeal where Mr. Riley does have an available remedy at the end of the day, should he prevail on his claims regarding the fee award. And assuming even if we get to that point, again, Mr. Riley, before he's even entitled to—
And can I ask you, and is that remedy the one that I was discussing with Mr. Snyder? Is the idea that if this went all the way to a final order, and you believe that Mr. Snyder's client would be within his rights to challenge that order, even if it was otherwise favorable to him in terms of the amount of compensation, to say, look, I was unfairly denied a step in the process. And then if the Court of Appeals were ultimately persuaded that that was correct, you think it would be an appropriate remedy to remand the case and start it all the way over again and see how it spun out, and maybe fees would develop in that scenario? Is that the remedy that you are saying is adequate?
Actually, I see another potential remedy, Your Honor. Typically what happens in these cases is after the compensation order is issued, there's a fee petition, and then fees are litigated separately. And then there would be a potential appeal from the denial of a fee award. In that circumstance, I mean, one potential remedy would be that should Mr. Riley prevail in his arguments, the court could simply sit it back for a reasonable fee award.
Could you, and when you say, I get a little uneasy when you say potential remedy, because I mean, many things are potential. Is the district's view that if instead of the remedy that I was just discussing, which you said is potential, but I'm not sure whether you think would be permissible. Maybe potential is equivalent to permissible, but in any event, with respect to the one that you're suggesting, is the district conceding, is DOS conceding that if in the context of are refusing to take review now, a final order, then a fee request, if this court were to determine that actually there ought to have been a recommendation by the mayor first and there wasn't, that would be an appropriate, that would authorize the court to grant the fees, some fees that were expended in litigation of the matter?
I believe so, Your Honor. I think that is an available remedy here because, again, the question is simply whether or not, if there was a misstep at the beginning of the process that would have otherwise entitled him to a fee award, and the remedy, I think, for that misstep would be to award fees.
We don't know.
Excuse me, wouldn't that be an implicit overruling of Kelly?
No, well, Your Honor, again, this is all premised upon the fact that Mr. Riley can advance a theory entitling to fees that is legally valid. Kelly right now would bar fees today, and it would bar fees in the future unless it's overruled. But if Mr. Riley were to come up with another theory as to why he's entitled to fees and were to prevail on that theory, then I think then the remedy could be a fee award rather than simply vacating the entire compensation order.
You're saying there's a way he could prevail on a theory that gets around Kelly?
No, Your Honor, I'm not necessarily saying that. I mean, if Mr. Riley comes up with another theory and wants to advance that theory, he can do so at the end of the day in litigating his fee award. And if he prevails on that theory, then again, I think the remedy could be, in that case, a reasonable fee award. Again, there's a statutory cap of 20% of the amount recovered. And so,
let me try to be clear about what you're saying. So imagine what happens is the following. We decline to take review. The matter goes back. There's a final order that is to a degree in Mr. Snyder's client's favor, and he files a fee request. And he says in the fee request, here is my legal argument. As a statutory matter, the mayor was required to issue a recommendation which would have triggered an informal process that might have resulted in my ability to recover fees depending on how things spun out. I was wrongfully denied that step in the process. Is the district conceding that if we were to agree with the first part of that was error, that actually when you read the statutes and you interpret them, they trump the regulation and the mayor is required to act? Or is the district conceding that it would be lawful and appropriate for the court to award as fees, the fees that were expended in litigating the whole matter?
Right, subject to the statutory, and I don't think the court would be awarding the fees. I think the court would be remanding to the CRB to determine what a reasonable fee award would be in those circumstances.
Yeah, but
Again,
the problem, counsel, is, as we said in Kelly, the final sentence of 1350B says in all other cases, there shouldn't be an attorney fee award. I mean, we have a statutory mandate saying you don't get to award attorney's fees unless there has been this informal process first and then noncompliance with the recommendation. And so I suppose you're just suggesting, kind of an equitable exception to that might exist.
Right, I mean, there was a statutory violation, so what's the remedy for a statutory violation? And again, if the court disagrees, that's fine. I think that the path Judge McLeese laid out would also be the other option. I think those are the two options I see. And again,
that's a really bizarre path though too, because let's say that everything gets vacated, it goes back to the informal process, and there's a recommendation, and the employer now has already advanced knowledge of what the ALJ and CRB are going to say, and so they can get out from under the attorney's fees that have already been incurred by the other side just by complying with that. So I don't really see how that would solve the riddle of how they would get their attorney's fees after an informal conference if they can't do this through an interlocutory appeal.
Again, I think, Your Honor, that those two paths are maybe not ideal, but I do think that gets the claimant to a remedy of attorney's fees, whether we go back and start from scratch and do the informal conference, or we say, hey, look, there was a statutory violation here. Either the agency or the employer did something they weren't supposed to do that deprived Mr. Riley of his right to attorney's fees. And the remedy for that is going to be a reasonable fee award, considering the statutory violation. I mean,
your time is fleeting or passing by, and we haven't talked about the merits yet.
Certainly.
Your opponent's argument in part is, if you look at 321530B, it says if there is there's some payment of compensation and then a dispute arises about amount, the mayor shall recommend in writing a disposition of the controversy. So what's wrong with his argument that shall means shall, and that a regulation that says, oh, never mind, we're not going to do that if somebody requests a formal hearing, is just not consistent with the statute?
My response to that is that that's not the argument he's made in this appeal, Your Honor. The argument he's made in this appeal is that the employer lacks standing to request a formal hearing, and that the employer is required to participate in the informal hearing process. Those are the two arguments that are advanced here. There's no argument here that the agency was required to do something it didn't do. And I think
assume for a moment that we can talk about that, but just taking for a moment your point that you're not sure that's an argument that's been made. Do you have a response to that argument, or do you think it's correct?
My response to that argument is that the Compensation Review Board should be the first entity to resolve that question. This court owes substantial deference to its interpretation of its statute that it's administering. That argument was not raised in the interlocutory appeal to the Compensation Review Board. And I do want to emphasize that
we already know what the CRB's answer to that question is from Kelly, don't we?
No, we don't, because again, they didn't answer that question in Kelly, Your Honor.
I thought the CRB made quite clear in Kelly that they thought it was based on the regulations, that it was perfectly fine for an employer to opt out of the informal process. Is that not clear in Kelly?
I don't know that that's clear in Kelly, Your Honor. Just like it was not briefed in Kelly before the court, is the court.
Well, no, I know that, and it was conceded at oral argument that it was fine. But I thought the CRB proceedings made it clear in Kelly that the CRB thought it was perfectly voluntary to go through the informal process, and an employer was at their leisure to opt out of it.
Correct, and I think that may be a separate question, Your Honor, than whether or not a recommendation needs to be made.
And can I ask? No, go ahead, Judge Gill.
I just don't think it is, because the only basis on which the only reason why there's not a recommendation is because the regulation says, well, once somebody opts out, you don't need to, then the informal process stops. And we know that. That's why we don't have a recommendation from OWC. So they seem very bound up to me, the two questions about if an employer can opt out and that ends the proceedings, then OWC did nothing wrong. If an employer can't opt out, then OWC needed to issue a recommendation. I mean, those seem to me too inescapable. I mean, what am I getting wrong in those two lines of
Your
thought?
Honor, I see that the arguments are tied together, but my point here is that argument has not been made in this case. And I want to be clear that Mr. Riley requested this appeal be consolidated with the rehearing petition in Kelly. And we all know from footnote 6 and 7 that Kelly makes very clear that the court saw tension between the statute and the regulation, but could not address it in that case because it had not been briefed and, in my view, had not been raised before the CRB. Mr. Riley has chosen not to make that argument in this case for whatever strategic reason he might have had. But I think it would be inappropriate at this point for the court to consider that without the Compensation Review Board being squarely presented with the question, particularly in light of the court's decision in Kelly. I think that would inform the CRB's consideration of the claim. And I think it should be given the opportunity in the first instance to decide that issue.
Can I ask you two things, I guess? One is, I take your point that this would be a question as to which Chevron type deference might apply. So ordinarily one might want to hear, if we haven't already heard, from the CRB about it. But if you were going to explain how the CRB could reasonably reach a conclusion other than that the mayor is required to do what 1530B says the mayor shall do, if there's no reasonable argument in support of you other than that it's mandatory, we may not need to hear from the board. So what's the reasonable argument that could be made in support of the idea that the mayor does not have an obligation to make an informal recommendation?
Again, without input from the Compensation Review Board, I don't have an answer for the court today on that. Again, I think it's incredibly important that the Compensation Review Board be given the opportunity to address that question. It hasn't been briefed here, and perhaps had it been raised here, the court would have had briefing on that issue from the Compensation Review Board. But we don't have that. And
can I ask you, just on the second half of the question I wanted to ask, I thought that Mr. Snyder's brief does at places say, his opening brief and his reply brief, if I'm recalling correctly, that the word shall is mandatory. And so what do you think is lacking from his briefing of the point so that it's not in front of us, you think?
Sure. I read his brief as saying it's mandatory that the employer participate in the informal conference. I do not read his brief as arguing that it is mandatory that the Office of Workers' Compensation issue a recommendation in every case, whether it's in the context of.
I'm reading from page 8 of his brief, of the petitioner's brief. This is toward the bottom, this penultimate sentence, the last final sentence. The statute using the mandatory word shall requires that a permanent partial disability award payable after the initial voluntary payment must be initially considered by the agency in the form of a recommendation. What's missing from that argument? I mean, that to me sounds like the argument that you say is missing.
Your Honor, that's one sentence in a brief that has two issues.
I mean, it's all. I mean, I think the gist. I think the argument really. I'm just picking out the first sentence I saw that seems to say that exactly. But the rest of the brief has that same gestalt that you can't bypass this procedure. And so if you're going to get really finite with it to say, oh, he's really just picking at the employer shouldn't be able to opt out. Well, then we get to get finite with the brief and say, well, he's actually also saying that the agency needs to make a recommendation quite clearly. I think that sentence says it. I think it's crystal clear from that sentence.
Okay, well, again, Your Honor, I think one sentence is not sufficient to develop an argument, particularly when we've got to look at the legislative history behind the act. The Workers' Compensation Act has been around for 40 years and has functioned this way perfectly fine for 40 years. So I think that, looking back at the construction of the statute, I think the Compensation Review Board should be given the opportunity to squarely address this issue in the first instance. I don't think that the employee's brief presents that issue to this court. I don't think the compensation.
Just to be clear, it's that entire paragraph. I just read the whole thing that spans page 8 or 9. It's probably elsewhere too. I mean, my recollection from reading these briefs is that was quite squarely presented to us, and I'm not having a hard time finding places where it's being argued.
Okay, well, Your Honor, again, I would disagree, and obviously my brief reflects my understanding and reading of the brief that Mr. Riley filed.
And to be clear, am I right in thinking that, let's say we were to disagree with you, and I know there's a separate point about whether it was adequately presented to the CRB, so I get that, and that would require looking at those filings, and also whether the CRB essentially decided it or was not quite deciding it. Those are separate topics. But that's the only defense you have, in the sense that if we were to disagree with you and to conclude that the issue is properly presented, then there is no other argument about why it should be resolved other than as your opponent suggests on the merits, because other than the points that have been made by the CRB and the idea that the regulation says that participation is voluntary, and our prior case law says participation is voluntary. So there are some points that are made, not so much by by DOES, but by the CRB. But there isn't some sort of general defense in the alternative. So you really kind of put all your eggs in the basket of this issue wasn't properly teed up. Is that fair or unfair?
That's fair, Your Honor. That is a fair assessment, I think. And again, I would just note also that were the court inclined to go beyond what I believe is in Mr. Riley's brief, that it's very likely issuing an advisory opinion, or very possibly issuing an advisory opinion in this case, because again, Mr. Riley has not secured a compensation order. And based on what we know about the nature of his claims and the employer's position, and the fact that there is little evidence or indication that he has suffered an economic harm, he may not secure a compensation order at all that would have otherwise entitled him to a fee award. So again,
But he'd get to go through the informal process. I mean, why is that an advisory opinion? That is
No, Your Honor, I'm saying if you go beyond what's in the briefs to consider whether or not there should have been an informal conference in this particular case, it could very well be an advisory opinion, because one of the other requirements for Mr. Riley to get a fee award is to secure a compensation order.
I'm missing your point. He's claiming a procedural right. If we were to write an opinion now saying, yes, he's entitled to that procedural right, give it to him. How is that advisory? I understand that the reason he wants the procedural right is because maybe it will have a benefit to him down the road, depending on how things play out. And he may or may not get the benefit that he's hoping for, but we would not be, we'd be giving him the procedural right that he's asking for. I don't quite see how it's advisory.
Well, again, the employer has requested a formal hearing. We know the employer is not going to accept the recommendation from OWC. They've already indicated they want a formal hearing on this. They've taken.
Why do we know that? We don't know what the mayor's recommendation will be.
Well, I think it's a fair inference that they skipped the process because they wanted a hearing. They didn't.
No. What I mean is, the mayor's recommendation might be, I don't actually think there's an entitlement to anything. And then the employer would have no real need to do anything. So anyway,
then the employee would request likely. I'm sorry. I apologize.
No, go ahead. I answer the question, and then let's try to wrap up. We will give Mr. Datt his 5 minutes, so hopefully he's not feeling anxious over there. But
sorry. Just the next step in the process would be, and then in order to get a fee award, the employee would have to request a formal hearing and prevail at that hearing, securing an award greater than the recommendation. And my point here is there's a likelihood that Mr. Riley will be unable to secure any award because he's not suffered an economic loss as a result of his claimed permanent disability. So my point is that process has to play out in any event, and given the unlikelihood that he may prevail on that we should wait and see what the outcome is. And again, these issues can be, I think, resolved once the compensation hearing has been finalized. So for all the reasons I've discussed, we'd ask that the court dismiss the appeal and the alternative affirm.
Thank you, counsel. Mr. Datt, we will give you at least your 5 minutes, so feel free to proceed.
Thank you, Your Honor. May it please the court, Douglas Datt on behalf of Intervenors, District of Columbia Water and Sewer Authority and the PMA Management Corporation. I candidly do not have a whole lot to add and just would primarily rest on what I submitted in the brief. I do believe that the claimant is attempting to essentially rewrite the statute and the regulations by requiring attendance at an informal conference. The shall language applies only if the parties actually attend an informal conference. It's a voluntary procedure.
That's not in the statutory language, though, right?
No,
I mean, that's something that you've gleaned from the regulations.
That's correct.
But the statute itself contains no such only if everybody participates in the informal conference. It says, you ask for an informal conference, then there shall be a recommendation. That's how I read it.
That's true, Your Honor. I just would submit that you have to read, obviously, the statutory language and the regulations in conjunction with one another. And essentially what's the regulations essentially state is that the shall applies only if an informal conference actually takes place. And if an informal conference doesn't if either party does not want to attend the informal conference, it's completely voluntary. And I believe that claimant is essentially asking this court to rewrite the legislative language, and that's not an appropriate function for this court.
Can I ask on the interlocutory appealability of this question? Counsel for DOES said, look, if at the end of the day, petitioner is correct that there should have been this informal process that was bypassed, that we might grant them all their back attorney's fees, because sort of, I'm not sure exactly what the theory would be, but that, there's a statutory violation by opting out of the process. And so we could give them all of their attorney's fees. That seems to be a pretty critical concession if we're going to say this is not interlocutorily appealable because they can get their attorney's fees on the back end. Is it a concession that you share? Do you agree that if we say you don't get to appeal this now, but at the end of the day, you win and you should have had that informal process, they can collect their attorney's fees for everything from when you guys decided to opt out of it and up to that point? Or do you disagree with that? And in which case it seems like an irretrievable right that they will have lost if we don't grant this interlocutory appeal.
Well, I would concede that arguably, if the claimant prevails at a formal hearing, he or she would have the right to file an attorney fee petition. So I think that's what.
Well, that's really among the most minimal concessions I've ever heard. He arguably could file a request. I mean, I assume it's indisputable he could file a request. Anybody can almost always file anything. But can you be more definitive? Do you think? Are you willing to concede that if you were to lose this procedural issue on on review from a final order of compensation, that it would be within the authority of the ALJ, the CRB, this court to award a reasonable fee that would include, the time spent litigating, let's say, from the moment of the request for a formal, demand for a formal hearing by the employer?
Your Honor, I'm always concerned about conceding anything because obviously I'm concerned about what the facts and what have you might be. But I think the scenario set forth by counsel for District of Columbia, I think that's an accurate assessment of how things would proceed.
Let me ask you about, and that was one remedy. Well, let me ask you this. Do you object to our writing an opinion that said the following? There's a dispute about whether this review, whether this court should take interlocutory review. And part of that dispute is whether there would be, irreparable injury, roughly speaking. And we find there is none because there is no dispute by DOES or by, DC WASA, the intervener, that if from a final judgment, Mr. Riley was able to establish that he had a legal right to a recommendation by the mayor, which he was denied, that the court, the agency in the court would have authority to fully compensate for a reasonable fees, a reasonable amount of fees relating to the litigation of the matter up to the up to the final order of the Court of Appeals.
I think the court would have the authority to issue that type of order.
I'm just asking if you would object. Do you object to? Do you say that such an opinion is fine with you, or do you say no? I'm not sure I agree with an opinion that would characterize my position that way.
No, that opinion is not fine with me. We would take exception to that based on what we've submitted in our briefs. So that would be my
Okay.
answer.
So how can you say that this is not an irretrievable right then if we don't hear it at an interlocutory appeal? I mean, how are they going to go about getting their attorney's fees if they end up winning this case? If it ends up being true that you should not have bypassed the informal process. If you're not conceding they can do that, then I have a hard time seeing why they haven't irretrievably lost a considerable right.
Well, all I'm saying is they could certainly file the application for fees. I'm just telling you, I don't concede necessarily that they would be entitled to receive their fees in that scenario.
Okay. I mean, but I'm just saying that it's in tension with your argument that this is a right that can be vindicated after final order. That's my only point.
Can I ask you, there was another possible remedy that was discussed, which was assume again that we decline to take review over this matter now, and then it goes back and there is a final determination that is to a degree favorable to Mr. Snyder's client. And he seeks review in the CRB and then in this court arguing that that final order was, I guess, unlawful because it should have been preceded by an informal recommendation, and it wasn't. So people, jumped the gun and didn't follow the correct process. If we were to agree that that was legally correct, which I understand you dispute, but let's say we were to agree that was legally correct, do you think it is an available remedy that this court could appropriately enter to say, okay, we vacate the final order and we vacate the CRB's order, we vacate the ALJ's order, the compensation order, we send the matter back all the way to the point where, imagine that the dispute has just arisen about the amount of controversy and now the mayor needs to issue a recommendation and then the process will start up from there all over again. Is that a remedy that you think the court could appropriately enter if the court were persuaded in review of a judgment, a final order, that there really was a legal entitlement to a recommendation from the mayor before there was a formal hearing?
I guess the court could issue that remedy if it felt it was appropriate. I think the more likely scenario, though, would be an appeal.
Again, just to be clear, my question, for sure we could if we thought it was appropriate. I get that. That's kind of circular. But my question is, do you contest whether that was appropriate, that would be appropriate if we reached that conclusion? I know you dispute the premise that there would be legal error in that setting, but assuming we found that, I'm just asking you about whether you separately contest that as a remedy. So my question is about what you will agree is appropriate or what you dispute is appropriate, not what we might or might do if we thought it was appropriate.
I understand. Now, I wouldn't necessarily dispute that that was a remedy that the court could impose if they felt that that was the appropriate way to go. I think the more likely scenario would be a petition for attorney's fees and then addressing it at that point. That's all I have, Your Honor. Thank you very much. I would again ask that the appeal be dismissed. Thank you.
Thank you, counsel. We'll give Mr. Snyder the 3 minutes he requested in rebuttal.
I appreciate that, Your Honor. Thank you. So I just want to kind of just start off. Your Honor had asked me a question at the end, and I kind of eventually got to what I wanted to answer, which is, really what this case, although this case in this instant is about the potential harm in the attorney fee shifting provisions. What it's really about is the policies, the procedures, and the case in controversy and standing to adjudicate that by any of the parties. And more so, it's about eliminating an undue burden on the injured worker in particular, but the system as a whole. And so, I kind of got to there at the end, but the problem that I foresee again with hearing the formal hearing, then an appeal to the CRB, then it coming up to Your Honors, and then vacating it and remanding it all the way back there's been then multiple proceedings before the agency, a proceeding before this court, 2 proceedings before this court potentially, and not just to mention that there's been an undue burden on Mr. Riley, who's potentially had to expend costs for things like depositions, expert witnesses, all that kind of stuff that could potentially have been eliminated, and that the system is designed to minimize or eliminate for an injured worker in order to gain what it is that they're entitled to. So,
Counsel, if I could just interrupt to ask a question there. I mean, the whole focus here, excuse me, has been on the extended expense involved in the kind of proceeding that we have finally arrived at today. I'm just curious, if you could put in relatively few words, why you didn't just follow through and get a final ruling from the CRB and then appeal that to us. I mean, you took a route that is, if the remedy is such that we go all the way back to the beginning and then we have to have all the attorney's fees to the end, is something that is partly self-inflicted in a sense by taking the interlocutory appeal here. I did not pick up why you were unwilling to just get the CRB order and then move up to this court. Final order.
Sure. So I think that, you know, we were kind of forced to have that course of action by the fact that the procedures were not followed, that the employer and insurer sought to deprive OWC of its mandatory jurisdiction over this matter in the first instance. And that's why we filed the motion to dismiss with the administrative law judge in order to try to have accomplished what the act and the regulations seek to accomplish.
I thought your answer was going to be because if you had the informal process finished to its end, then you would be entitled to every cent of attorney's fees after that recommendation if the employer didn't want to pay it. But because they bypassed the informal process, you're not going to get any of those fees that have been incurred since they bypassed that proceeding up until now. So, I mean, why isn't, I thought that was your argument.
Well, that's part of it. But again, this really is about something broader than attorney's fees. And I don't want to, you know, that's again, part of the issue here. But really, again, the bigger issue is the regulations prescribe a process. The process was not followed. And then as far as attorney's fees specifically, there's years of jurisprudence with the National Geographic case that state that anytime an injured worker elects to bypass an informal conference or if it's their application or if the employer's tendered compensation, then there's years of jurisprudence that kind of bind us to the fact that this has to happen in order to proceed in potentially the way that we would like to. So
let's just assume for a moment that attorney's fees is not the driving aspect of this case, and that the appropriate procedures are. I still don't understand why you, if that were the case, wouldn't have gone just directly to the CRB and be done with it. I mean, they could rule quickly. They issued a ruling, howbeit an interlocutory one.
Right. And again, it's about what the process is as prescribed by the regulations. Again, I'll just draw your attention one last time to 219.8, which was not addressed in Kelly and I did speak on earlier, that says that each controverted claim shall be investigated by the office, meaning the Office of Workers' Compensation. So it's again, that's what has to happen. And I don't think that going to the formal hearing, exhausting, you know, certain resources on Mr. Riley's part to take a deposition of a doctor to litigate it, when potentially that could be obviated if it was just heard by the Office of Workers' Compensation in the first instance, and then they make a recommendation that everybody agrees with, and none of that has to happen.
Thank you. I got your point. Thanks.
Okay. Thank you, Your Honors. And I believe that my time has elapsed, so I'll leave you with that.
Thank you, counsel. We appreciate your briefs and your arguments, and the case is now submitted.
This court is now adjourned.